think with that said, we can go ahead and get started. Looks like a great group. We really appreciate everybody hopping on. So hopefully we can have a good discussion like Laura was saying earlier. Feel free to use the chat with any questions or comments you might have if you can't unmute. And if you have any technical issues, please also chat me and let me know. I'll be handling that while the session is going on. And we're going to start, I think, with Terry Walker, going to do the presentation first, real brief. We'll have a discussion. And then we all, like Laura said, we do have a couple of cases today afterwards that we can review. So, Terry, I can, oh, Laura, is something.
Yeah, Jay and I can monitor the chat for you, Terry, so you don't have to worry about it. We'll
Right.
Okay.
Put questions
Yep.
there.
And just give me 1 second, Terry, and I can pull up the slides and navigate them for you. Just tell me when you want me to move them forward.
Okay, sounds good.
All righty. Give me 1 second. Right. Everybody able to see that? Get some head nods. Okay. Go ahead, Terry, take it away.
Okay, so how I'm going to start from the beginning, like when we get a referral and we go out and assess the family in regards to whatever the allegations are in the referral in the assessment that we receive. And if they're, so when we go out, if there are present or impending dangers involved with the family, then that's how a case gets opened. So we have two types of cases. We have cases where there's court involvement, and then there's cases where there's just an open CPS case and we put services in the home for the family. And when we start working with a family, whether it's a court case or just an open case, we do a safety plan, and we put services involved in our safety plan, and we have informal and formal providers in our safety plans that we may put in people that can go to the home to check on the family if the children are still in the home. And then we have services for kids that are out of the home that we put in place. So once we do a safety plan, CPE stands for case plan evaluation. So we work with the family and we do a case plan, and we set goals that the family will work on, and what the worker and the family will work on. And for like our in-home cases, and if there are issues with our in-home cases, they may turn into, if the family's not working their case plan, and there's continuing safety issues, then we may at some point remove the children and it ends up being a court case. But then sometimes families work their case plan evaluate or case plans, and then work towards getting their case closed. So every 90 days, we evaluate the case plan. And that's when we make different goals. If we've accomplished goals and other things have come up that need to be changed, or there's other issues that come up with the family, then we change our case plan and put services in for the family to work on. So, with any case, our case closure, I mean, we work towards permanency from the beginning. Once the case is opened, if kids are removed, we work towards permanency for the child or the youth, because we do have kids that are in our custody through youth services. If you can move the slide. So caregivers and youth have made sufficient this is how a case gets closed. Caregivers and youth have made sufficient progress in addressing case plan outcomes related to demonstrating appropriate thoughts, feelings, and behaviors for CPS, enhanced caregiver protective capacities, where that is the parents have are making sure their children are protected and have increased their caregiver protective capacities. For youth service, FAST scores, which is the FAST scores have reduced to the degree that services are no longer warranted, or community resources can continue to meet the youth and families' needs. Caregivers can adequately meet the needs of their families, and safety threats become controllable without DHHR intervention for a period of no less than 90 days. It may be an indication that case closure could be appropriate. So after services are out of the home, we try to monitor the family to make sure that there are no issues in 90 days and that the family is doing well before we close the case. Next slide. Importance of family support and case closure. Next slide. Establishing family supports at case closure. So it's real important when we're working with families that we work with the families to find community resources or other people that the family can rely on, that can continue to support the family after the department is no longer in their home and their case is closed. Next slide. Permanency and reunification. For children in custody, permanency planning begins as soon as the child enters care. Permanent placements must be achieved in a timely manner. The total number of children in foster care for more than 24 months, or the children in foster care for more than 24 months should not exceed 20% of the foster care population at any point in time. So if a child, we try to get permanency. When kids go into care, we develop a permanency plan. Our permanency plan is always reunification, and we work with the parents regarding reunification. And we do a concurrent plan, and that concurrent plan could be adoption, it could be legal guardianship, or something like that. But we're always working towards the goal of permanency for these children, for our children in our care. Next slide. Reunification is always the first choice for permanency planning when a child is initially placed in foster care. Permanency options are reunification, adoption, placement with relatives, or legal guardianship. Aid a child over the age of 14 to attain independent living skills necessary to become a successful adult. Next slide. Reunification for all children under 16 who enter care through juvenile proceedings, children who are placed in foster care through voluntary placement agreements, and those children who have been in foster care due to child abuse or neglect proceedings for less than 15 months, whose parents have not committed aggravated circumstances, reunification should be considered the primary permanency plan. That's always our plan for children are to be returned to their parents. Next slide. Achieving permanency. Reunification services defined through strength-based comprehensive family assessment, focused on strength and resources within the family and community, addressed in an open, inclusive forum with the family, goal-oriented and focused on building skills, focused on strengthening the family's problem-solving abilities, appropriate and timely to meet the child's needs, concentrated on identifying family supports, and provided in a culturally competent manner. Next slide. Such services may include, but are not limited to, family support groups, individual group or family counseling, parenting education, mental health services, substance use, misuse, or substance use disorder treatment services, assistance to address domestic violence, structured visitation, career training, job placement services, homemaking, chore services, and/or family-focused therapy. So these are all services, especially when kids are in care, that we use to work with families to achieve their goals and to get permanency for our children with reunification. So that's all the slides. I don't know if anybody has any questions.
We did have one question in the chat, Terry. It was from Elizabeth asking, is West Virginia recognizing a notification versus a referral? And I'll know, Elizabeth, if you can unmute and maybe clarify or add on to that.
Yeah.
Hello. So my question basically is, there has been cases where I need to call in for our pregnant moms. And so it would be more of like a notification of substance use instead of a referral technically at that point to CPS. Is that something that West Virginia is doing? I know that I've watched a few webinars and things that different states do, like a notification process at that point. And then of course, after the child is born, then we go ahead and do the referral process. Is that something that we kind of do that you guys are kind of doing in West Virginia as well?
We do have that process. If someone calls centralized intake and makes a referral on a pregnant mom that doesn't have any other children, we get in contact with that mother to see if we can provide services at that point, to get them into, if they're willing to do services, if we have appropriate contact information. A lot of times people call in and don't have addresses and phone numbers. Of course, we can search our system to see if they're receiving a medical card or something like that, but we do get those. Those are very infrequent that we get those, but we have gotten them, and we try to contact the mother to see if they are willing to do services prior to the child being born.
Okay, thank you.
Yeah, that's great to hear, because I was not aware that that prevention piece was available. I had a question on slide 6, where there was a bullet point about the total number of kids in foster care should not exceed 24 months for 20% of the kids in foster care. Is that, I just wanted to clarify that.
Let me find that. Okay. So normally, like, we have part of our policy is that if we have children that are in foster care 15 out of 24 months, that we have to request termination of the parents' rights. And we have to file a petition. Well, there's already a petition, but then we have to, if the children are in care for more than 15 out of 24 months, we have to ask for termination.
And where is that? I'm just curious, like, where that regulation or requirement for you guys, where does that come from? Is that sort of a DHHR mandate, or?
I do believe that's in our statute and policy.
I have a question about that, Terry. So does it matter where in the process the parents are? Like, if things are going really well and they're following their improvement plan and moving forward, but COVID slowed everything down. And so if they're getting up to their 24 months, but they're doing really well, does that change this kind of?
So the process is, and a lot of our kids are not in care up to 24 months. There's usually before 24 months, there's permanency has been achieved or in the process of being achieved. So parents are given if they're given improvement periods. So we go to court, and if the parents are given a post-adjudicatory improvement period, once they're adjudicated, they can have an improvement period of 6 months, which is a post-adjudicatory improvement period with an extension. They can get an extension if their improvement period are going well and they're doing all their goals and doing their services and everything's going well. They can have an extension of 3 months, which you're talking up to 9 months then. So then once we get to the post-adjudicatory improvement period, if things are going well, then we look at reunification. We put a reunification plan in place. We start doing unsupervised or in-home. We start with in-home visits with a service provider going into the home, and then we decrease those to where then they're in-home visits, unsupervised, and then we do weekend visits, and we get that, we get a plan in place to do reunification. If after their post-adjudicatory improvement period, if they're still working, but there's still problems, a lot of our families get a dispositional improvement period, which is another 6 months with another extension of 3 months. So hopefully during that improvement period, we can get all the issues addressed. And then if, obviously if there's still issues, they're not working, then we can ask that their improvement periods be revoked. But most of our children are not, they're still in care up to 24 months, but there's been permanency. They've either are being adopted or with legal guardianship.
I think sometimes as the evaluator who gets pulled into the parental fitness evaluations at the end, I see a very select group of families. And so it's nice to hear kind of the whole process and how maybe it works with most families and not just that little select group I see.
Yeah, we try to do the parental fitness pretty early in the process. Usually during once we get into court, that's ordered at the preliminary hearing. Or if we file a non-emergent petition, that's what we call it, a non-emergent petition, where we pass the preliminary, we go straight to adjudication. At that hearing, at the adjudication hearing, we get those parental fitness evaluations done pretty quick due to the fact that they make recommendations as to what the parents need to be doing as far as if they're appropriate, if they're going to be able to do an improvement period, number one, and the process of if they're going to be able to achieve their goals.
So what percentage, when you think about like open CPS cases, would you say are actually out of home placements versus in-home placements with active
Okay.
cases?
I'm going to speak about Harrison County, just because the majority of our cases are out of home cases where kids are placed out of the home. I would say probably 90% are out of the home. So it's a higher percentage than we have in-home cases.
Can you share an example of when you guys would make the decision to do an in-home placement versus like an out-home? Because most of us are probably familiar with the out-of-home placements, but like what would an in-home placement be like?
Okay, so an in-home case would involve where we can control safety. If you have a situation, I'm trying to think off the top of my head. If you have a situation where, okay, I'll give you an example, and it's a simple one where there's educational neglect. We wouldn't necessarily remove those children for educational neglect. We do file petitions on educational neglect, but educational neglect isn't a safety concern. So we open those families for services, get services in the home, work with the parents on getting children to school, but we do file petitions on educational neglect because a lot of our kids miss a lot of school. I mean, we have kids that have missed 50 and 60 days of school, where statute is no more than 10 days is considered truancy. So that would be an example of a situation where we'd have an in-home safety plan with a family.
Okay, great. That's really helpful. Any other questions that people have?
I think we can switch gears to the cases, but first, thank you to Terry. That was great examples, and appreciate you doing it. What turned out to be a 3-person presentation turning into a 1-person presentation, so we appreciate it.
Not a problem.
Okay, so we have a couple of cases, one from Laura Lander, one from Anna Butcher. I don't know who wants to fight to go first. Any preference on that?
Anna, you can go first.
Okay. All right.
Okay.
Anna, let me pull up your case and you can just walk us through it real briefly and then we'll have a discussion. So just give me 1 second.
Sounds good. Yeah, sorry I was late, guys. I was on the phone with CPS actually.
Go ahead and go for it.
Okay, so this client is a single female with a history of substance use disorder, currently in recovery for the last 300 days. She has 1 child who is in the foster care system. She works full-time, has an apartment, reliable transportation, but this was not always the case. Her CPS case began when she was homeless due to leaving an abusive relationship. She had applied for services, but was having trouble obtaining help without an address. Her child had missed a great deal of school during this time. She was in active addiction at this time. Her child was removed after a complaint was filed from an anonymous source. CPS found that she did not have a safe living situation. Her child is 13 and they have a good relationship despite the hardships. She has had an improvement period and an extension granted. Currently, her final disposition is approaching, and the state is seeking termination at this moment due to 10 low-level positives on her urine screens, her sweat patches, and blood screens over the past 6 months. She denies use, but has concerns of exposure at her place of employment, which is a gas station where she handles money often, and her 2 co-workers both are in active addiction. Her visitation was once per week, supervised for 3 hours. She has requested an MDT to ask about increased visitation, but her lawyer has not gotten back to her yet about when the next one will be. She has weekly group sessions with the Coat Clinic as well as individual sessions with her therapist. She attends at least 2 NA and AA meetings per week and has completed parenting classes. She has maintained contact with her caseworker consistently. The 2 have a good relationship. Her caseworker has been helpful in obtaining increased visitation, but has concerns about her work environment. Her exposure at work is an issue. The stress that she is under from trying to keep up with all her sessions, work, as well as court MDTs is concerning. Her motivation is currently good, but she has had many ups and downs in the case that may start to affect her motivation. Her car is older, repairs can be expensive. If she loses her car, she'll be unable to get to all her appointments and to work, which could create a downward spiral. She knows her employment exposes her to addiction daily, but she must work to maintain her home and transportation in order to attempt to get custody of her child back. She had tried to find other employment, but so far has been unsuccessful and has concerns that she will be exposed at most jobs due to the high rates of use in town. She says she feels helpless sometimes and has been upset at delayed visits due to worker shortages. She also identified that her ex has violated the restraining order and that she often feels scared, adding to her already high stress level. What advice, if any, would you give her to ensure she has the best chance of reunification instead of termination?
Okay, so just something that caught my eye about in your report, we had a couple of moms that we were working with that were working in same environments, like dealing with money, and then testing positive on their drug screens when they hadn't been. And so we recommended that, and I know this is something that isn't going to be comfortable, or but we recommended that they wear gloves at work, because dealing with money, you're dealing with people you don't know, and obviously with the drug problem, it can sleep through your pores and your hands and stuff. So we recommended that they started wearing gloves at work, and they quit testing positive.
Oh, that's a good idea.
So just something, for
Added
future
protection.
use, for that situation.
Go ahead and feel free to unmute or put any questions or advice you have in the chat. Either way is fine.
It's interesting, and listening to Anna's case, it reminds me of a whole bunch of other cases. So, which is the idea of, individuals who get caught in this place of almost, it's like a catch-22 of needing to expose themselves to substances because of the need to work, which is aligned with their goals. In the case planning evaluation, probably, they need to have work, they need to have transportation, and they need to have a safe home. And many of, the places, depending on the educational level of our clients, is not gonna end them up with jobs that are free from substance use. Often they encounter jobs that are where other workers, or they encounter people in the public who come into their workplace intoxicated or offering them substances. So that, like, this is a really common struggle that we see, and the domestic violence piece also, I think is a struggle. I'm curious about the domestic violence piece. Any kind of recommendations when individuals, there is an order of protection and it gets violated? Like, what would CPS want to see the client do in those circumstances?
So as far as CPS, if he's coming to her place of employment or wherever, and there's an active protective order in place, she needs to contact law enforcement, and law enforcement will deal with that issue. I mean, he can be arrested for violating that protective order, but that needs to be initiated by her, that she follow through with those kind of things.
Any other thoughts from others? Just hearing that case would sound familiar.
She also may want to reach out to, like, the victim advocate at the prosecutor's office. I know ours works closely with victims, and she keeps in regular text contact and different things.
And so that's with the prosecutor's office, or Brianne. Someone's talking to Brianne.
Yes.
So county by county, that would be the same process, or?
Because usually if there's a DVPO, sometimes there's also criminal charges that go along with that, domestic battery charges or something like that. And so the prosecutor's office obviously is involved in those charges, or with the charges, the criminal charges. And I do believe probably most prosecuting attorney's office have victim advocates.
Great, thank you.
I have a question about just how decisions are made based, if the age of the child has any bearing on outcomes, like an infant or 3-year-old versus a 13-year-old or a 15-year-old in the same circumstances. Does that matter at all, or this is a minor, so this is kind of what happens no matter the age?
Okay, so our policy is at the age of 12. Children are asked if they want their parents' rights terminated or not. That doesn't mean that that doesn't happen, but their voice is considered as far as whether they want their parents' rights terminated or not. But that doesn't negate the fact that this child's 13. I mean, she would obviously, she has a GAL and her caseworker, and they would be talking to her about those issues as far as her mom's rights being terminated, how she feels about her mom's rights being terminated or not. And then the difference is if whoever she's with, if she's with a family member or in foster care, if the mom's rights aren't terminated, then that she can't be adopted, but they can do legal guardianship.
Any other comments or questions? Let's see, we got one in the chat. What happens if the child wants them terminated, but the department doesn't think it is best?
I don't know that that question would be posed to the child then, if that's not what, where the case was headed.
Correct. I mean, if we're looking at termination, then that question is posed. But if we're not looking at termination, because some parents can get an Alt-5, just which means they have done some of the things on their improvement periods that, but they're not going to be able to full-time take care of their children. And some of our parents are given an Alt-5. So when that happens, their parental rights are still intact, but they can't take care of their children. So that's when we look at legal guardianship with whoever the child is with. I mean, if the department is recommending termination, that's when that conversation would happen with the child 12 or older.
Can you talk
Thanks.
a little bit about an Alt-5? Just, I don't know if everybody's familiar with that process, how that goes. I assume sometimes you come up against that decision at the end of like the 24 months, like you got to make a decision and you go the route of Alt-5 versus termination, and then what happens from there, if that's accurate.
Correct. So if a parent is given an Alt-5, that means their parental rights are still intact. And then wherever the child is, and depending on the situation, the parent also has to agree to the legal guardianship of the child for that permanency plan to happen, for that permanency to be accomplished. But at that point, with the Alt-5, whenever they, down the road, whether that's 5-10 years from now, if they get their, if they get to a point,
Act together.
I didn't want to say act together, but I was trying to find the right word other than act together, because I just think that probably isn't appropriate to be saying. But if they get in a place in their life where they have housing, they've taken care of you know, if they had a drug addiction and they've been clean and they've gone to treatment and, you know, they want to look at getting their child back, they can petition the court to show that they've had a change in circumstance. And a lot of times when parents get all fives, a lot of, I mean, I know just in Harrison County, where parents have gotten an alt 5, the kids are with a family member, and they're able to maintain contact with their child, as long as it's supervised, and so on and so forth. They put that in the order that there can be supervised contact.
Are they ever able to live with that family member where the kids are, or no?
That's a case-by-case basis. Probably we would not recommend that. I don't think that that would be something that would be in the order, that they could reside there, but and that's never happened in any of our cases. But they can have, you know, like phone contact, and they can go to if it's with an aunt or a lot of our kids are with their grandparents. So they can go to the grandparents' home as long as it's supervised. And as long as they're not visibly intoxicated or high or anything like that. And that would, and a lot of times that's what happens after the department's not involved anymore.
Mhm.
And we've had cases where the parents live back in the home with their kids at the grandparents' home. But while we're involved, they can't be living there.
Right.
Just for clarification too, I hear you calling it alt 5. In our county, we always call it disposition 5 or dispo 5. So that's just something that may vary county to county.
I think it's listed as alternate disposition 5.
Got it. Thank you for that clarification.
Anything else? That was great. Catherine, thanks for your question in the chat. I guess if there aren't anything else with this case, we can switch over to Laura's. So Laura, just give me 1 second here.
So I chose this case and because it's sort of a lot like a lot of cases, and it has some similar themes to Anna's also. And in part I struggle with like the stepwise chronology, understanding like what needs to happen when the limitations and mandates, Terry, like you talked about, like once you hit the 24 mark, you guys are required, to make decisions, even though the client may actually be doing well. And I'm sure people have all kinds of feelings about that. So this is kind of along those lines. So Anna's was much more detailed than mine. So this is a broad brushstrokes one. So patient was referred to CPS due to neglect related to active substance use. Currently where she's at is her rights have been terminated and the children are in the process of being adopted. So that's jumping to like what happened. And then resources that were involved: criminal justice, CPS, foster care, and treatment. She currently remains in treatment even after her rights were terminated, which doesn't always happen. And we're really happy to see that that did happen. So this removal happened during, as someone mentioned, COVID. So things moved very slowly and confusingly during COVID, but it played a role in the delay of her case and things moving quickly. So her children were removed from her custody. Initially, what we see is people often, their use gets a little bit worse for a while because it's a crushing, necessary but crushing blow for individuals where often they don't see any hope. She was able to come out of that, and Child Protective Services was recommending she go to a residential treatment program, which she did before they all shut down. And that's actually where I first met her. I before she came to treatment with us, I met her when she was in the residential treatment program, and she completed that, and then came to outpatient treatment and sober living. So when in this, in this example, when in the process does I assume the clock starts ticking for the 24 months at the time of removal. Is that accurate?
Yes.
And then it can be a long period of time. It sounds like it can be a long period of time before the improvement period starts, say, because if someone is incarcerated, which she was for part of this initial period, or if someone's in 28-day treatment. So when would the improvement period start if someone has those experiences of not entering recovery right away and continuing to use, or incarceration or residential treatment? Like, when do you figure out when the improvement period starts?
I mean, part of her improvement period could be her being in treatment.
Okay, so it could start then.
Absolutely.
Okay.
Absolutely. Because a lot of times when we get into this process, it's recommended that especially with substance use, and depending on the severity of the substance use, if they continue to use substances, and the MDT is going to recommend that they go to inpatient treatment, go to detox, and then go to inpatient treatment. And so all that can be part of their improvement period, or happening during their improvement period. So,
but incarceration would not, I'm assuming.
I mean, our courts have given parents improvement periods while they're incarcerated. Okay. Because they have, depending on where they're at, they have classes they can take incarcerated. Like they offer parenting, they often offer drug abuse treatment while incarcerated. I mean, we've had psychologists to go to do their parental fitness and their psychologicals while incarcerated. Okay. So, I mean, that's happened in our cases. So, I don't know.
Okay.
So there has been.
Okay. And then how were some of the delays that were caused by COVID craziness and workforce shortages, both with your guys' referring to services that were not available due to workforce shortages, or visitations, or things not happening, or parenting not happening because of workforce shortages? How did that impact kind of this hard stop 24-month?
So with our cases, I mean, obviously we still continued to work. I mean, we continued to remove children, we continued to do all those things. Service providers, we did visitation, and it didn't last like the whole time. Gosh, thinking back. So COVID hit in March. I couldn't keep my workers out of the office. They were supposed to be working from home, but I couldn't keep my workers out of the office. They were here, and obviously we did what we had to do, but services were done remotely. I mean, with the people that we could do services with remotely. Visitations were done remotely for a period of time. But I do believe, if I'm thinking correctly, we went home, the workers went home in March, late March. And we resumed visitation like August, September in person. It wasn't anything that was a long period of time. But during that time, we did visitation remotely, and services were done remotely. So those things all continued to happen just in a remote manner.
Okay. And there are, I mean, there are workforce shortages, like nobody is available to transport the child or supervise the visit. And you guys don't necessarily do that. I know you contract with folks to do that. Like, how does that get figured into sort of beyond your control, beyond the client's control, figured into like that can cause delays in that like 24-month period?
Okay, so, you know, we make referrals for services immediately. I mean, there's no delay. And if we can't get as far as visitation goes, with the parents, if we can't get a service provider to do the visitation, then we do it ourselves. I mean, our workers, and we have case aides, and we have a case coordinator and we have two, but we're down one, but we have case aides that do those visits. If the case aides are not available, then the worker does the visits, or one of the workers do the visits. I mean, everybody pitches in and we get the visits done, because that's part of the court process, and they cannot go lengthy periods of time without seeing their children.
Mhm. Mhm. Okay. So any other
And we usually start visits within a week. Like when we take kids, by the next week, a parent is having a visit with their children. I mean, it's not fair to the parents and it's not fair to the children.
Well, isn't that assuming that they are doing certain things, or?
No. Nope. That's going to be part of the court process, and they're going to be ordered visitation. Now, I have to say, there are some counties that do things differently, and not all counties and all judges do things the same way. I know there are some counties that parents have to have 2 clean drug screens before they can have visitation. In Harrison County, it's not that way. We do not, our parents, unless it's court ordered, and which is very few and far between, our parents see their kids. Now, if they come to the visit and aren't interacting appropriately and are apparently visibly intoxicated and can't carry on a communication with their children or interact with their children, then we end the visit.
Right.
But their visits don't in Harrison County depend on their drug screens.
Do other folks have questions? Go ahead.
They don't depend on drug screens in Mon either.
We still have some time for any other questions or comments.
So I know we have some of our folks on this call who work with children on a regular basis. So Kristen, any thoughts or questions based on you've worked with kids for a long time?
Yeah, no, I actually found, oh, it froze for a second. I found this really helpful because I've had a few cases where I was really confused on what happened and only got like the last information from the CPS worker. I know I've had one where like the GAL and the CPS worker were like, you get to break the news that mom is terminating. Kid knew it though. We had lots of conversations about that prior to the conversation. She kind of wanted it to happen. But even understanding, I have a kid right now who is in kinship care with her aunt. So I'm assuming that like an Alt-5 is happening in that case, because she talked about being on probation for truancy and some of her own substance use. and just navigating that. So this was actually really helpful for me to understand why some things happened and understand the timeline completely. Thank you.
I wanted to bring up, because I know 24 months was brought up a lot in here, and a lot of our cases do not last that long. A parent should be demonstrating a substantial likelihood that they're going to participate in improvement period to get an improvement period, or their attorney can fight for that, and the judge can grant that, even if we disagree with that. So a lot of our cases do end sooner, but that's kind of the end of the road if they've gotten all of their improvement periods that have been possible.
Yeah, with the case I presented, and that's good to hear, I'm presenting an outlier. The sad part was, so she definitely had a delay. She had at least a 6-month delay that she was responsible for. She didn't get into recovery right away, and then she was incarcerated for 3 months, and then she went to treatment. So I don't know exactly when the timing started. Interestingly, she credits her CPS worker with the success of her recovery early on, because she had no supportive family, and that her CPS worker, she said, was the only supportive person she had in her life for like the first 6 months until she really built recovery supports. So she actually had a very positive experience with CPS, and yet her rights were terminated like right around the time when she got her year of sobriety. And she had visitation up to that time. So I was sort of taken aback, like, oh, what happened? And then got some history about the delays in the beginning. And it was kind of like, our hands are tied. We can't extend this anymore. She was at her limit, despite actually having been very stable. She eventually, she had secured stable housing and moved out of sober living, and it was not gonna happen that her kids came back. Just like an interesting outcome. And I assume that was probably hard for CPS folks to see too. Like, that's not the outcome you guys would want either.
Brianna, did you say that you're in Mon County?
Yes.
Ooh, okay. I'm in Mon County too, but this is kind of a big question, but I'm just going to ask it, and maybe we can have this conversation over email. But I'm wondering, as a child therapist, Chris and I work a lot with foster and adoptive kiddos, a lot of kids in care. And I'm wondering, like, in a perfect world, what would be our role kind of collaborating with you? I often feel like, oh, I want to connect with the caseworker and like talk more about this kid, but I'm not sure how to do that, if that's just giving you guys more work. I guess I really want to be useful in the process, and I'm not sure how to do that.
A lot of times I find it easiest because we've worked with other child therapists, and the easiest way to do that is email. If you can just shoot us a quick update about their progress or some concerns you have, email is the best way. And even if you want to start with me, and then I can forward it on to the individual worker and then let you have their contact info. And then if you can join in the MDTs, once we establish that contact, that would be super helpful.
Can you put your email in the chat?
Yeah.
And I think it came up on our last CPS Echo, the concern about security of email and sharing personal health information through email. Colleen, do you remember where we landed on that? I don't remember where the solution that we landed on.
I don't know that we landed on a solution. I remember the conversation as I kind of straddle the WVU and the DHHR world. The reality is that outside of systems that have Epic, people share communication through email. And that kind of just a reality of our work. But if people using Outlook and WVU system, if they put bracket, secure bracket
Right.
in the subject line of their email, then it's sent securely, and it's my understanding we're okay to send PHI information that way. And then as the recipient of that email, it looks really funny.
But for people, it's like for Jenna to communicate with Brianna.
Right. So Brianna, it's gonna look funny to Brianna when she gets it. Let me, can somebody
The-
send me an email, secure, a blank email, and I'll share my screen so you can see it.
While that's happening,
Yeah, I
part of the issue moving forward will be the transition of the IT services at WVU. It used to have a couple of different ones. You had main campus, you had HSC, that is now becoming one. And so, yeah, so I think we just have to be careful of that, because I think they're going to crack down on a lot of this stuff, because they're going to be overwhelmed with trying to do IT across all the campuses that have so many different needs in the health sciences center versus somebody just trying to get, class information out the downtown campus. So Colleen is right. You can do that bracket thing. My worry moving forward is that it's going to be a little spotty, and that's just because of a reorganization kind of deal.
I'm sorry. I realized that by Laura sending it to me, I'm at work, and so it just comes up normal for me because I'm in the system.
So this is a barrier for us, so we'll need to continue to work on.
Yeah, well, and on
this.
the other side, DHHR also has a way to send secure emails, although I'm less familiar with it, and I actually don't have access to send secure emails that way. But there's like, is it Virtue? So they can also send secure emails. And basically what everybody has to do is once you open the email, you then have to like double click where it tells you to click and sign into whatever your email system is. And so it's verifying that it's you that's opening the email in particular. So it's a little bit frustrating. But I think it's important, maybe, sending an email, hey, can we set up a time to meet? Or, I mean, I guess if we're not sending PHI, it wouldn't have to be a secure email. You could set up a meeting and say, I want to talk to you about a patient, and then on the phone, have that conversation.
Exactly. Yeah, that's a good workaround. I appreciate that. Well, I know we're at time. Thank you, Terry, so much.
Oh, you're welcome.
Informative. I know I had so many questions, but I appreciate you answering them.
No problem.
Yeah, we'll be meeting next on May 17th. So be on the lookout for that information. Appreciate Anna and Laura presenting cases. Great job. And we will see everyone in a couple of weeks.
All right,
All
take
right.
care.
See ya.